Hey friends, criminal defense attorney Ryan Pacyga, and today I'm going to answer the question, what's the difference between reasonable suspicion and probable cause? We hear these terms thrown around in law all the time, and you might hear them on TV or in books or in classes. So I'm going to tell you what these things mean. First, reasonable articulable suspicion. In other words, to articulate suspicion. So an officer, if they want to make, for example, a traffic stop, they have to have reasonable, articulable suspicion that a crime was, is, or is about to be committed. And so, if they want to make a traffic stop, for example, they can't just have curiosity to do it or a hunch or idle curiosity or be what's called on a whim. All of those things don't count. But once in a while, law enforcement will sort of overreach. Let's say, for example, they see your car leaving a bar at bar closing time. You exit the lot properly, you signal going out of the lot. You're driving down the road, and maybe there's a slight little weave right in your own lane. You didn't leave your lane of traffic, you didn't touch the lines, just something like that. Sometimes officers will overreach and they might want to pull a car over for that. The reason is because maybe they got a hunch you're leaving at bar closing time. They think, well, there's, half a chance you're over the .08 limit or something like that. So they decide to make a traffic stop. And later on, we have a hearing in a case, and we argue to the judge, hey, they didn't have reasonable, articulable suspicion to make that traffic stop because this was just curiosity or a hunch by the officer. They can't articulate an actual violation of a traffic stop or a traffic law to give them a reason to stop the car, okay? So that's reasonable, articulable suspicion. They have to articulate reasons for a judge that show they had reasonable suspicion that a law was being broken. Not that you might, be drunk later or something like that. If they can't point to a traffic infraction, for example, then they don't have reasonable, articulable suspicion. Another thing might be happening. So let's say they get a search warrant to raid somebody's house, and you're a bystander in there. You're a friend. You don't live in there. You're not the target of the search warrant. They don't see anything illegal going on with you, and they come in to raid it. You've got to be able to be free to leave at that point in time if you're not a subject of it, generally speaking. And if they want to detain you or keep you there to investigate you, they've got to have reasonable, articulable suspicion that you are committing a crime or have committed a crime. Otherwise, they got to let you go generally, unless you're listed on that search warrant. That's another example there, okay? Now let's move over to probable cause, okay? Probable cause is more than reasonable articulable suspicion. It takes a little bit of reasonable articulable suspicion to stop someone, whether you're walking on a sidewalk or driving a car or whatever like that, in order to investigate whether a crime's committed here. It takes more. It takes probable cause now to make an arrest, okay? So let's go back to that DWI scenario. Let's say they pull you over and they've got reasonable articulable suspicion that you might be drunk driving or that you violated a small traffic law, like you're going 33 miles an hour in a 30-mile-an-hour zone. Okay, they got reasonable articulable suspicion that you've committed a traffic infraction there, so they pull you over. Now they go up to the car, they start talking to you, they ask if you've been drinking, you say yeah, and your speech is slurred, maybe your eyes are a little bloodshot and watery. They get you out of the car, they give you field sobriety tests, and they say that you didn't perform well on them. And they want to give you a breath test on the side of the road, you blow over the limit. Now they've got probable cause to arrest you for DWI and take you to the station or to the hospital and give you the real test back there, okay? That's probable cause that an offense has actually been committed or is being committed. It's more than just suspicion. It's higher than that. It's more likely than not, generally, that a crime has been or is being committed, and that's probable cause. Probable cause is also what judges have to do when they read a search warrant application. They have to determine that there's probable cause in order to believe that a crime's committed, and that wherever they say you can search, that the evidence of that crime will be found there. Okay, so what do we do in these situations here? Well, as a lawyer, when we get a case, we look at the evidence. We hear your side of the story. We want to hear your side of it because a lot of times the evidence doesn't say your side of it. And then we want to look at the police reports, the recordings, the body cameras, the dash cameras, any auto recordings, picture, surveillance videos, you name it. We look at all of that, and in looking at that and hearing your side of the story as well, we get a picture or an idea of whether law enforcement has violated your constitutional rights, either by detaining you without reasonable articulable suspicion, or arresting you, or getting a search warrant without probable cause. So I hope that clears up some misunderstanding or some curiosity that people have about the difference between reasonable articulable suspicion and probable cause. And if you like this video, let me know. If you have questions, you can always find me at arrestedmn.com or call me at 612-339-5844. And remember this, you were meant to roam free. We'll try to keep it that way. Take care, everybody.